Yeah.
Can we get started?
Yes, please.
Very good morning again, everyone. It's an absolute pleasure for the Planning and Urban Management Agency to be a part of the training today. And we're very happy to have been invited to also share some knowledge and also to learn from our forum today on some good planning tips for EIA. So I would just like to start our presentations today by giving a short overview of the principal legislation that governs and manages our office called the Planning and Urban Management Agency Act. Just a disclaimer before we start. Unfortunately, our legal manager couldn't be with us today. She is our acting CEO, so she's got other commitments, so I apologize for that. And I will try my best to give an overview. And what I'll do today, because obviously, you know, legal documents can be full of jargon and full of you know, finer details. But I'll just take you over some of the key sections, which I think are very relevant to our training today, and also very key points for us as a general citizen of Samoa to understand. And I'm supported today by my colleagues online and also my fellow colleagues who are with us can help me provide clarifications should you need it.
Please.
Right, so this presentation will just cover a short background on what the PUMA agency is about, and then we will focus on the actual act itself and its key points. And then I will just end with a short summary just to recap what we have learned today. Oh, we have a hand up from Greg.
Yeah, so sorry, just wondering if you could just enlarge just share it as a slide presentation. I'm not sure how I can see it, but I'm not sure about for others who might be joining in online. It might be better if it's the full slide. So just click to the presentation, because at the moment I'm seeing seeing the slides off to the side. Now I'm not seeing any. That's it. Thank you so much.
All right, so this is just an overview of the contents, but let's get straight into it. Sorry, we just, oh yeah. So what is PUMA exactly? Now, PUMA stands for the Planning and Urban Management Agency, and we are a government agency and currently situated as a division within the Ministry of Works, Transport and Infrastructure. Now, PUMA itself is made up of key sections, and that is mainly the strategic planning, which looks into town and environmental planning and policymaking. Our sustainable development section, or our development assessment and consenting team. This is who receives your development consent applications and assesses them, as well as your EIAs. This is the first point of contact for your EIAs. We also have the urban management team that deals and resolves issues stemming from pollution and amenity type of issues. We also have our compliance monitoring and enforcement team that monitors development to ensure compliance to the law. And then we have also attached to our agency project management units for the National Street Addressing Project that you may have heard of, and the Apia Waterfront Development Projects. So, but what exactly is it that we do? So PUMA is the national regulatory body for development. And its primary objective for its regulatory role is to ensure that sustainable development is achieved. It's the National Environmental and Social Safeguards Agency, and we are also responsible for the National Urban Town Plan. Now that we have had a brief understanding of what PUMA is and does, so now we will look a bit closer at its legislations and the institutional framework. So in governing the work that PUMA does, there are key documents that inform what we can and cannot do, and this is how it looks. So at the very top, we have the PUMA legislation, or what we call the Principal Act, or the PUMA. The Planning and Urban Management Act 2004. So just to note, 2004 was the year it came into effect. And this is our highest level legal document that instructs all our work and responsibilities. Now that act is then further extended down into what we call regulations. And these legal documents provide more detailed instructions on how to carry out specific parts of the act. These regulations are also regarded as a direct extension of the law. And then right underneath that, we have what we call the library of internal office documents that help support these legal documents. So we have policies, standards, plans, strategies, guidelines, etc., codes, and all of these documents work together to support the objectives and the goals of the PUMA Act. So now coming down to the Act itself. Before we actually go into it, every Act has a preamble or opening statement. And in this one statement, it gives you an idea of exactly what the Act is hoping to achieve. And for the PUMA Act, the opening statement is, and I quote, "It's an act to establish the Planning and Urban Management Agency and to implement a framework for planning the use, development, management, and protection of land in Samoa in the present and long-term interests of all Samoans and for related purposes." So I think this is a very good short summary of what you expect to see in the PUMA Act 2004. But before we actually get into it, it's really key here that we understand the definitions of keywords that you will see all throughout the Act. And it's also very important that when using a legal document, you have to use the definitions that are attached to it. And it may be very well different from the way we usually understand the word. So I want to point out 3 keywords and how our Act defines them, because it's very important that you remember that as you are reading our law. And those words are use, development, and land. So land is defined not only as the physical plot of earth that you are used to, but it also includes buildings and any other structure permanently fixed to the land. So fences, a water tank, any other structure that also goes under the definition of land. Even land covered with water, so the water bodies, lakes, rivers, even the sea itself could, if you really expand the definition, the sea can be defined as, land covered in water. As well as any estate, interest, easement, privilege, or rights in or over land. So that is the entire definition of land that is used within the Act. Secondly is the word use. So use in the PUMA Act is defined as the existing use and also the proposed use for the land being developed. And then we come to the last keyword, which is development. Development under our Act covers a range of different physical acts, from constructing buildings or any structures, any form of carrying out an activity on land, but it also covers the intangible act, which is even changing the use of your land is considered a development. So I think it's really key that you just keep this in mind as we go along our presentation. I'll just touch on this very briefly, but like most acts, they set out a whole line of objectives, what it is that this legal document is aiming to do. And we have just gone through Greg's presentation and our discussions. We talk about things about sustainability, environmental protection, social protection. And you will find this that all the acts, whatever area it covers, usually share the same objectives. So it's not different for the PUMA. So one of the objectives is, providing a fair balance of sustainable use and development and protection of land, The other is, enabling good land use planning, its integration into all levels of national policies and planning. It's about promoting urban planning and growth of, urban centers. And the aim is to secure a pleasant living environment for all our people. It's about protection of our public utilities and coordinating all these utilities. But all of this culminates to the one goal, and that is to balance the present and future interests of all Samoans. And now let's take a closer look. The Act itself is quite large. It consists of 12 parts and 4 sections. It has 106 specific clauses. But I would like to take you to the 4 main sections of our Act, which governs our daily work. You can, if you would like to read the full Act of the law, it's available online. You just Google PUMA Act 2004 and it will come up either on our website, but I know a lot of other government agencies also shares our Act. So you can do that if you would like, but I would like to take you on just some very key points, small key points, that I think is very important for all of us to remember. And first of all, the first key point that I would like to make comes from Part 5, which is the Planning and Development Assessment section, clause 34, and it states that all development needs consent from the agency under this Act, unless specified within a special sustainable management plan or regulations. And for ease of reference, at this current moment, there is no exempted development. So there is no SMP or a regulation that has a specification to say this type of development does not need a PC. So right now, everything needs consent. So if you remember the word development, which this is referring to, it means use of land and physical activities carried out. Another very key important part is that works cannot commence until consent from the agency has been received and it is in force. So you must get all your permits in place before you start your activity. And how do you go about getting a consent? You must come to PUMA to apply for a consent, a development consent application. And you must lodge your application, pay the subscribe fee, and await the assessment and the decision. So, and this is where our environmental impact assessment process will come in. This is a very key part, and I will not dive deeper now because it's actually in one of our sessions after lunch, which we will go into a lot more detail. But this is just a key point to remember now, and we'll talk about the actual process later on. So you must apply for development consent prior to your activities starting. And another key consideration of our PUMA Act is that it also looks into protecting the amenity. An amenity is defined as a pleasantness of an area and a place from issues such as excessive noise, excessive dust, visually offensive signage, water quality, traffic, excessive traffic issues, smell, wastewater, odor issues, and even from stray and wandering domestic animals. So this is actually another key function of our office, is resolving public complaints resulting from these type of issues. Under Part 8, Enforcement and Legal Proceedings, Clause 18, this is a key one, and it talks about that the agency reserves the right to issue stop orders to cease any activities that are illegal, meaning if you have not applied for your development consent, or you are one of the people creating the issues that we just talked about in the previous slide, you will be issued with a stop order from the agency, and it will be issued to the those types of people described on the slide there. Landowner, or that person occupying the land, or any other person with an interest in the land who is creating that illegal activity. And very important too is the powers of entry, and most people do not actually realize this, but authorized officers of the agency actually have a power of entry to enter any land, dwelling, business, or premises at a reasonable time to issue out an order for you or to carry out any other parts of this act. So this power is very similar to those of police officers. But the very key consideration that we must remember here is that this is the only reason why they will come, they must enter your land. It's to carry out enforcement of our act. And it must happen at a reasonable time. So if you will not expect someone from our office to come at 4 a.m. in the morning, banging on your door, asking to come in to give you an answer. It must occur at a reasonable time. And it also has to be directly related to carrying out an action from our act. So if you can't block them from coming in because they are carrying out the activities or the responsibilities empowered by the law. So I think this is also a very good point that we would like to remind. Often people think, only police officers have that right, but in fact, for this specific legislation, it also empowers our officers under the agency to be able to have entry into the premises that they can go and issue their orders for. And moving on, in addition to that, if complicated cases comes and stop orders are not adhered to or complied to, people still carry on their activity. Very often we then take the enforcement to Supreme Court, and our law supports that. We then take the proceedings to the Supreme Court for the Supreme Court to then give out a remedy or also a more stringent enforcement of the order that we had carried out. And then we got to remember what's happened, and it's a criminal matter now. So it has a more weight to it in terms of the situation. And these are very important things for us to remember. And other key points that we would like to point out is that the Act also states that PUMA is responsible for the management of sustainable management plans or land use plans, you might know them as, or land zoning plans, as well as any other town planning documents. Number two, it also, under the Act, gives out the structure and responsibilities for the Planning and Urban Management Board and its composition. So it's chaired by the minister, representatives from communities, as well as certain government agencies. And the third point is that, and very importantly too, is under our Act, it gives out the structure as well for a planning tribunal. It's an independent committee selected by the Chief Justice to assess appeals by anyone who is unhappy with the decision of the agency. So this really does ensure fairness all around, that developers do not also feel that PUMA is coming and stopping things unfairly. There is also an avenue for them to take appeals to, should they feel unhappy about the decision of the agency. And like it says, it's an independent committee, so it's selected by the courts. And just to summarize with some key takeaways from the points that I highlighted today, this Act, the PUMA Act, really is about ensuring that the developments are considerate of its surrounding environment and the people living within. It's there to ensure that whatever negative impacts come out of developments, that there are ways that you can reduce or mitigate them and ensure that we preserve our natural, social, and economic spheres. But at the same time, it's not just about looking at the negative impacts. It's also trying to see what are the positive benefits can come out of development and what are the ways we can amplify those benefits and at the same time reduce the negative impacts. It is also about promoting proper town planning and the design of sustainable urban centers. So, the growth of our town, the growth of our urban centers in Pia and Salem, that's what another sometimes a lesser known function of PUMA is. And very key point that I would like to make is that, very often we hear this, PUMA is so anti-development, they're just here to, give us a headache and they're always bothering us to tell us to stop this, stop that. But I just want to make a point that really this, the Act and also our office is not there to hinder or stop or discourage development. We're actually on the opposite. We want to come and help you ensure that your development is sustainable, not just for right now, but in terms of the future. We take into account, you know, the current climate, not only financially, but environmentally, and ensure that your development can withstand those impacts now. And a lot of times too, our process is about, it encourages input from your neighbors, your surrounding, all the affected people. And once everyone is on board and happy with it, you will find that development is more socially accepted by all. So, and that's because the basis that this act is based on is fairness for everyone, not only for the developer, but also for the people and for the environment. And then with that, that brings us to the end of what we call the express version of the PUMA Act 2004. Thank you very much. So I have my colleagues online, hopefully, and Tal, we can take some questions and answers. But again, like my disclaimer, I am not a lawyer. So please, I'll try and help you with what I do know, but if there are any things that get too out of hand or too technical and I do not want to give you wrong information, I will happily note it down and with an email address, and I will go ask our lawyer. She can help you clarify. But if there is anything else that we would like to know more about, I'm happy to take some questions. Thank you.
Thank you so much. It's really well done, and you speak like a lawyer. Yeah, that's good. I open the floor, please. I have a whole lot of questions here. I don't know why. I don't want to ask them. Please, colleagues. Please, colleagues.
It's a lot of information.
Craig, any question from, yes, please, Craig.
Yeah, well, I'll use my opportunity for a question to prompt Tamara. What's the biggest hurdle, or as in what's the most common trip up point for a developer or proponent who is proposing a development? What's the most common mistake you see done?
Thanks, Greg. So that's a very good question. And if I were to give an answer, and I think it's the most common trip up point we would see is the actual consent application. And that is a challenge I think our office is also observing, is that still, and you would see this act was from 2004, so we're nearing the 20-year mark of the act. But still today, we still find that a lot of people are carrying out development without coming in to apply for the necessary permits. And I think that's where the trip up then comes in. And I think that's where the thought of, oh, you're just here to stop me. And, you know, you're a nuisance. Like, but again, if we had applied for that permits, you know, well ahead of time, this process would be a lot smoother. But I think that's one of the main challenges that our office is still finding at this time, is that people are carrying out activities without actually getting permits applied and approved prior. Thanks.
Thank you. Yes.
Thank you, Tamara.
Thank you for that presentation. I think one of the important things that our tourism authority and the Samoa Association should always be aware of in these developments in tourism, to always ensure you ask the operators, do you have a development consent? The first thing you should always ask. As Tamara has pointed out, there is no exemption under the Act. So even if it's on customary lands, because they would always come up with that excuse that it's their land, they can do whatever they like on their land, but that is not the case under the law. So thank you for that reminder.
Thank you. And if I just may add on that point, again, and I think people might get offensive with the word consent, right? The word itself. And the way that this is termed is that you must seek consent first from, PUMA, who's a government agency, before you start your activity. And I think a lot of our people may take offense to that, to say, why am I going to a government agency to get their consent first before I build my development that's being paid with my hard money on my land? But I think it's just, it's a term, but consenting really, it's a planning permit. I think it's the same meaning as that. And what you're actually coming to get is that you're getting a check from a government agency to say, oh, all the elements in your development have passed and they're regarded as environmentally safe. It's socially safe, as in, you are not passing on any impacts to the people, or and it's not also going to create any economic problems for the country. So, a lot of people see it, I think, from that angle, to say, why am I asking permission from a government agency when they're not paying for any part? But I just want to clarify that. And when you also come in, we do not exactly tell you to say, oh, you must, this is how you should design your, we give you tips, and then that's for you to think about and to design according to. And usually the tips that we give you, it's from the law. So we're helping you make sure that your development is legal, first of all. So I think I just want to say that, because, we do hear it often in our office. It's often the billing in many images, and we're seen as, you're a nuisance, you come and stop us, you make things more expensive. But often the reason why it's expensive in the end is because you started something without getting your permit. And then when you apply your permits, you realize that a lot of your activities are illegal, then you must change it, then you must put in more money so that's when it becomes expensive. But if you think about it as if you had, come in earlier, start your planning process before, it would probably have saved you a lot more money, because then you know exactly what you're paying for, and you know exactly the activities that are regarded as legal. And then you can start and then only focus your resources on it. So I think those are just some of the points that I would like to just.
Thank you.
After him, then you, man.
Is there a threshold or of sorts for you to require a consent? For example, take beach valleys as a case. If you've got 5 beach valleys that you already got consent for, and you want to add 2 more, do you still require consent for the additional 2?
That's an excellent question. So, for example, the situation or the scenario that we've been given is a beach valley of 5 valleys had applied for consent, it's been approved, but now further down the line, they want to add 2 more. So do you need to apply for development consent? And the answer is yes, you do. Because that consent given to you at the time was for 5, and it was under the assessment of the impacts of these 5. So every time you add, build, and even interestingly enough, even when you reduce it, so let's say you want to take things off, remove them, you still do need to come in to apply. And basically the idea about that is whatever activity you carry out on the land, you have to come and apply for it, because we have to assess what the impact of that is. And I think that's really the basis of the thinking behind this planning process is whether you're adding things on, you're adding impact, or taking things on, that also has an impact. Whether it's a good one or a bad one, that's what the assessment is about. So you must and notify the agency and apply for a new permit every time you change an element of your development.
May I ask how much is a permit?
A permit, well, I will be actually covering that in a later session, but I just want to notify you right now, our permits are very cheap. They're not, building permits are usually the ones that are above 300, but just to give you a context right now, any development under 50,000, this is the value of your development, is 30 tala. And for developments over 10 million tala, it's 2,000 tala. So that's like less than even 1%. So I just want to, I will be covering that in my later session. I'll also be taking you through the application process and what you need. So you're very friendly people, I promise you. And we'll be very happy as well to assist you with your planning of your development. So it's not just about applying your permit. Even when you want to, start talking about a development, that's one of our services for you to come in, and then we can give you information and tips about even the other permits you need. For example, the fire safety permits of FESA, the LTA drainage permit when you need to discharge. So that information usually sits in our office, and you can treat us as a first point of entry, and then we can identify all the costs or all the affected permits that you also need now.
Thank you. Yes, ma'am. Excellent.
So yeah, Putu, I have a question. With your PC process, I want to know where the EIA comes in the process, and what's the difference between the EIA and the peer? Because with our role, we have to review when we receive the EIA, but we have received some applications with no EIA, no peer report.
Thank you. Thank you, Mr. Swan. This is a very good session. And this is actually being calculated, and I will go into it now. And this is a very good, so the question from Mr. So was, under the development consenting process, when is an EIA needed? Because they have seen, they're also one of our partner agencies in reviewing certain DCs. They've seen that sometimes they get an EIA report, sometimes they get a report, and sometimes they don't get nothing at all.
I know the answer, but it's a headache to that.
Yes, and I think this is, now we're coming to the roots of Mr. So's headache problem. So I'm happy to provide a solution.
Excellent. I like the discussion. Please, let's continue. Let's continue this. Thank you. And you'll answer that in your next part of
I think I'll just touch on it, but we'll go into it. So just to give her some relief for her headache right now, not have her wait for another hour. But basically, an EIA is determined. It's an extra assessment report that's determined by the PUMA based on the nature or the scale of your development. Because mind you, we get like the word development is defined, it means any kind of activities. When you build up, let's say, a fence, which is just, wooden post and that barbed wire, you require DCA. When you build a resort like Town Messina, where you're creating a new island, removing, you need a DCA. So those are two very different scales and natures of work. And based on the generated impacts that we see, we will then request, you might need an EIA, you might not need an EIA. So for smaller scale works with, very little impacts, we would not need them to do an environmental assessment report. But for, once we start seeing the nature of the works, there's earth clearance, there's cutting down of trees, they're filling it up, or, putting in drainages, discharging, and that's when we will trigger them to EIA. And just quickly touch on it too. Under the agency, EIA is sort of like the umbrella term, but there's two type of level reports under it. It's the PER and the STA, funnily enough, also called a full EIA. So P for PER stands for Preliminary Environmental Assessment Report and a Comprehensive Environmental Assessment Report. So there are also two different levels, but I will be taking you on that in more detail in the DCA process, and we can have more discussion. But that's just a quick answer as to why you may see sometimes that you get a full EIA, sometimes it's a PER or a PEAR or no EIA, but it really is based on determining on the nature and the scale of the application as well.
Interesting. Thank you. Any other question? Yes. Please.
I have another question, Tamara, and I used to work for PUMA. So and then I went into the private sector, and then as a citizen of Samoa, I have been affected by development. And so, but this is something that's also very useful for our tourism sector in terms of having the getting clear information of how you can lodge a complaint with PUMA if development affects you or your family land or your well-being, and then take that to PUMA, because under the legislation that is something that is protected under the PUMA Act. So I have two questions, Tamara. Have you had a case where your planning tribunal provision has been activated? And two, has PUMA been able to address those grievances or complaints lodged by people affected by developments that have been issued consent by PUMA?
Thank you. These are very, very good questions. So Ofera has correctly mentioned that is one a very key part of our act, is that we come in at resolving issues or complaints from people who are then affected by development. So not only do we come on this side and assess development, at the same time, when people have a problem, and this is our right as citizens as well, that our amenities must be protected. So when you do have a right to complain, and that is also another function of our office, is to step aside and also address the complaints of the people that are against a certain development. And Ofera's questions were, number one, like I mentioned in my presentation, there is a planning tribunal which is activated by the Supreme Court, and it's selected by the courts to be an independent panel to assess complaints of somebody who was not happy with the decision made by PUMA. And the question was, has it ever been activated? And the answer is yes. Not recently, but we've had some historical big cases where this planning tribunal has activated. So without naming names, there was a very controversial case about a development A being, let's say, an entertainment-based sort of development. And right next door was development B that's new, and they were trying to develop. Oh, sorry, actually development A is an entertainment / accommodation place. So they're about hosting people, giving them a relaxing environment. But next door, development B was going to build a huge church headquarters. So then there was a very direct conflict between the uses of two. And so what happened was PUMA was trying to be the ones trying to help resolve the issues of both. And what we actually did was, when one does not want to listen to the other, we elevated it up to the planning tribunal, and they gave the final and the most final decision on that matter. And it was enacted, because then it was like a court. You have to listen to it. If you don't, you're going to be charged and taken to jail. So, yeah.
Thank you, excellent.
Sorry, and then the second question, I was like, sorry, Joker, if I could just attend to the second question, which is, does PUMA go on about resolving complaints of people coming from developments? And the answer is yes too. And on the daily, we get complaints. Some of them are very easy to resolve. It's just, one neighbor is not happy about the other neighbor's music being too loud. So what we do is, get them sit down together and say, oh, can you turn down your music, during hours, when people are sleeping. And then the neighbor says, oh, okay, I'm sorry. And then we have some cases where the nature of it is very big. This neighbor has built an entire house halfway in the neighbor's land or something like that. And it's a house, it's an investment. And it's not something that you can say, oh, can you please remove that by tomorrow? So there are also very cases in the nature of this as well. And we have to be impartial. That is the role of our agency. And in order to be impartial, you have to do the groundwork of assessing each side and then coming up with a decision that is fair. And if either side is not happy, We also have our courts that we do go to as sort of like the last stop. And then whatever decision that they give is final. And even, yeah, so that's the quick answer.
Thank you. We've got one more question and then we go for lunch. We'll ask for.
Oh. Yeah, apologies. I think you might be covering this later in the session, but might have another commitment, so I'll ask it now. In terms of the EIAs, can anyone prepare them? And if not, how can you become qualified to do a study?
Another excellent question. So it's about who gets to prepare an EIA, and I think the answer from our office and the recommendation is that it has to be somebody with environmental background, first and foremost. And another key point to this is that EIAs very, very rarely are prepared by one person. It's usually a team of consultants and team of consultants with different backgrounds. So you can have engineers, you can have social anthropologists, you can have, it really is, because mind you, it's the word environment in EIA does not mean your physical green environment. It means all your surroundings, the people, the air, the water, and then your land. So it really is a teamwork. It should be a team. But our main recommendation is that at least the person putting it together and the one that is the focal point with PUMA at least have an environmental background manager, so like an environmental conservationist, environmental manager, to be the person at least that puts the together. That's the.
Thank you very much. I know there are this.
Oh, sorry.
Stella.
Hi, Stella. Thank you.
Okay, I'd just like to add on to Tu's answer. Thank you, Tu. PUMA also has a list of consultants that have prepared EIAs before, and we're currently working with. So if whichever developer is looking for an EIA and they don't know where to start, they're welcome to come to PUMA. We have a list prepared, and they can just have a look and go through the list, and they can contact whichever consultant they wish to work with. Thank you.
Thanks, Stella.
Thank you, Bill.
Excellent. Thank you.
But we need to break for lunch. But they will come back and